Hello, my name is Audra, and today I'm going to talk all about the basics of estate plan. So there are two main basic estate plans that we can do for you. We can do the last will and testament, or we can do what's called a revocable living trust. Now with both of these estate plans, we want to make sure that you have your incapacity documents in order as well. Your incapacity documents are going to help you before you pass away. So there's four main incapacity documents. The first one is a durable power of attorney. The durable power of attorney, it's pretty long in the state of Florida. Ours is about 24 to 26 pages long, and it gives a detailed rule book of what your agent can do for you. So they can do multiple things. They can open up your mail, they can open up a safe deposit box, change beneficiaries, use your credit card, write a check, open a bank account, close a bank account, pay your credit card bill, pay the lawn man, pay your mortgage. This is a person that you want to make sure and trust that they have financial wisdom. They can handle your affairs. If they can't handle their affairs, then they can't handle your affairs. So you want to make sure that they're good with money and that you can trust them. Because this power, it turns on the day that you sign the document. So this is over your everyday, day-to-day living decisions. So make sure that you trust the person and that they can handle finances. The three other incapacity documents are dealing with your healthcare needs. So the first one is a Hipaa authorization. Hipaa just says who can call the doctor, so who can gain information about you. So once that information is gained, or they can call the doctor and see what's going on with you, then they can say, okay, well, we got to make a decision. When they need to make a decision, they're going to look for the designation of healthcare surrogate. Designation of healthcare surrogate, it says that if you are unable to make a medical decision yourself, then you have listed people on the healthcare surrogate that can make it for you. So it's not a document that specifically says, if I am in this condition, then please do this. If I have this, then do this. It is all based off of a communication between you and the person that you name. So you want to make sure that you can have an open and free conversation with the person that you name about quality of life, about end-of-life issues. Because the more that you discuss with them, the easier it's going to be for them at that time. If they understand and they know exactly some of the things that you want, then they can make that decision in confidence that that is what you wanted. And they're just there as your advocate for you when you can't discuss it with the doctor yourself. But in addition to the designation of healthcare surrogate, we also provide a living will. So the living will is a document that is very narrow and it's very black and white. It says that if you are in a persistent vegetative state, an end-stage condition, or if you're terminally ill, and we also have to have two doctors agree that there is no chance of recovery, then you do not want to be artificially prolonged. So in order for this living will to turn on or to take effect, you have to be in one of those three conditions. We also have to have two doctors agree that there's no chance of recovery. So if you meet all those parameters, then you are telling the doctor that you do not want to have artificial means to keep you alive. If they've already given you those artificial means to keep you alive, then take them away. So that is your living will. It is very different than a DNR, a do not resuscitate. That is something that you get from your doctor that we will not provide for you. So the main incapacity documents that we can provide is your durable power of attorney over your finances and your everyday living decisions. Then we do your Hipaa authorization, your designation of healthcare surrogate, and your living will. So those documents, they all work together to help you before you pass away. But then we have your main estate planning documents. Again, we can either do the last will and testament or the revocable living trust. It all depends on who your beneficiaries are, what your assets are, and how you want your beneficiaries to get your assets will depend on which avenue is best in your situation. So a last will and testament, this comes into play after you pass away. Okay, it only comes into play after you pass away. And it is the document that goes in front of the court that tells the judge who to give your assets to. It is our advice that we want to try and keep all of your financial assets out of probate. We want to make sure that the only asset going through probate is your homestead property if your main estate plan is the last will and testament. So the ways that you can keep your assets out of probate for financial institutions is making sure that you have a beneficiary listed. Sometimes beneficiaries are called POD, or pay on death, or TOD, transfer on death. But you just want to make sure that you have beneficiaries, whatever they're called, listed on all of your money. So checking accounts, savings accounts, stocks and bonds and mutual funds, IRAs, 401ks, life insurance, anything that you can have a beneficiary on, you want to make sure that you have someone listed there. Because when you have someone listed there, that is a contract between you and that financial institution, and that is going to prevent that asset from going through probate. So the asset that you can't really put a beneficiary on is your house or real property. So with real property, if it is your homestead residence and you are giving that homestead residence to a relative, then it gets a shortened probate time and a certain amount of money, generally around $2,000, and it takes about 90 days. Now, if you are giving your home to someone that is not your relative, like a stepchild, then that home is not protected with the 90 days and the $2,000. That is going to get the longer probate period. It can take anywhere from 6 months, 9 months, a year and a half, depending on if there are disputes and what else is in the probate. So it'll also cost anywhere generally from around 1% to 3% to get that asset out of probate. So again, it all depends on who your beneficiaries are and how many pieces of property you have and how you want those assets to get to your beneficiaries will determine if the last will and testament is best for you or the revocable trust. So when we have an estate plan that is based off of a will, again, we want to make sure that you have beneficiaries on all of your bank accounts and that the only asset going through probate is your homestead property and that you are giving it to a relative of yours. If that does not fit your situation, or maybe you have 2 pieces of property, or you want to give money to minors, or you want to control that money after you pass away for the beneficiaries, then generally we look for a revocable trust as your main estate planning document. Your revocable trust becomes effective the day that you sign it, okay? So it starts living with you. It is associated with your social security number, and you maintain complete control over the trust and the trust assets. So you can sell every piece of property that you put in the trust and spend any money that you put in the trust, or give it all away. You can change who the beneficiaries are, and you can change who's in charge. So the main person who's in charge, they are your trustee. And at first, you're the trustee. If you become incapacitated or when you pass away, then we have a successor trustee come in and either help you while you're incapacitated or disperse the assets after you pass away. So the revocable living trust, it gives you a lot of flexibility with your assets. You can control the money for your beneficiaries, say until they get 25 or when they graduate college, or you can say they can get 10% when you pass away, and every year after that they can get income off of the money. And on year 10 they can get it all. There are a lot of different specifications or details that you can add into your trust to make it specific for your situation and specific for each beneficiary that you have. So generally, if you want to give money to a minor, we cannot do that in a last will and testament. That is why we look for the revocable trust. Also, we look for a revocable trust if you have more than one piece of property. If you have more than one piece of property, we want to try and prevent each of them from going through probate. And the way you do that is through your trust. So think of the trust as a bucket, really. And anything you put inside your bucket, you will prevent it from going through probate, and you can control how it gets through to your beneficiaries. So if we put your houses in your bucket, we put some money in the bucket, that is going to ensure that when you pass away, if your house needs a new roof or your house needs to be painted or new landscaped or something like that, that your trustee can reach into your bucket and use your money to help repair your house before anything is split and divided to your beneficiaries. So it gives you some added layers of protection. You can also add in layers of protection by naming successor beneficiaries. So if one person passes away, do you want it to go to their children? Well, what if their children are married or minors? We have built-in provisions where that money is still held in trust for those minor beneficiaries. So if you are in need of an estate plan or you have questions, please call us. Our office number is 352-399-6944, and we can have a consultation. We can go over your specific details and figure out which type of estate plan fits your needs and your assets best. So again, our number is 352-399-6944, and my name is Audra. We look forward to hearing from you. Thank you.